Hello, everyone. Very warm welcome. Our ACIL lecture at lunchtime today. Great to see you, in spite of obstacles and train strikes and everything. It's also a great pleasure to welcome Hollis, who's a professor of law at Temple University, who today joins us to speak on his new paper co-authored the deals on large language models and international law, a very initial dive. Duncan has a wonderful track record, engaged in many different regimes of international law, general questions of international law. Together with Dr. Akanda, among other things, he co-convenes the Oxford process on international law, protections in cyberspace. So many things I could highlight. Maybe to mention your involvement in the advisory role in drafting the False Restatement on the Foreign Relations Law in the United States. It's a very important point of reference for legal scholarship and practice. Your guide to treaties, and so on and so forth. It's really great to have you. Thanks for making the trip, for passing by, sharing your thoughts on this topic. It resonates with our researchers and colleagues just as well. Without further ado,
Thank you, Professor Venzke. So first of all, thank you for coming. And what I understand, there's been some train logistical challenges. So for those who are in the room made it, and for those online, thank you as well. I should begin with an emphasis on the very initial dive. I think Ashley would tell you if she was here. This is a paper that's been kind of years in the making. We've both been talking about how myself and Cyber, on machine intelligence, we've been writing conceptually for multiple years about, well, what could this technology do, or how this technology might interact with international law. And so it was this path, I think a little bit of more than about a year ago, we decided, well, let's try it out in a very, semi-empirical, quasi-empirical, I would not say empirical without some sort of qualifier to it. And I'm going to see if the slides will slide. There we go. So what I wanted to do is kind of working through the paper. The first thing we tried to do was think about how international lawyers might use large language models. We came up with a non-exhaustive list of 5 kind of first-run use cases. I'll talk about those in a bit. And then because it is a symposium piece, we were not in a position to do all 5, but we did offer kind of 2 preliminary case studies that I want to walk you through as it were. And then perhaps most interestingly, for the generalists in the room, talk about the way we think large language models are going to function in the future for not just international lawyers, but the discipline as a whole. I assume at this point, everyone in the room is familiar in some ways with large language models. But basically they are trained on large sets of data. And I maybe my own way move this so that those of you, there we go. That will surely block something later on, but for now, you can see. So these are algorithms that beginning in November of 2022 with ChatGPT 3.5, I believe, kind of began to change the world in that they started actually interacting with users in a way that were, I think, quite remarkable, right? Like they can produce nuanced and coherent responses to questions, and that there are now a proliferating number of these, principally ChatGPT, I think, but also Meta AI, Copilot, Mistral, Notebook. I'll talk about a few. We did not work through all of them. DeepSeek is one that's come out of China recently that claims to be working with much less energy than some of the traditional models and the like. Now I've done this again, so let me come over here. See, this is taking me back to my COVID days, teaching online. So I think one of the things that we thought was fun was like, well, let's ask ChatGPT what it's good for. And it basically gave us this kind of, this is what I can do for you, sort of, also amazingly positive things, right? But note at the end, it has to provide that reassurance. But don't worry, I'm not going to replace you. I'm just going to improve your efficiency and effectiveness. And so our project basically was to say, well, we are somewhat aging public international lawyers, Ashley and myself. Let's, we think we're experienced enough to be able to evaluate it against, background, doctrinal assumptions and the like. So let's see, again, very modestly, what we might do. And the first thing we were thinking about was, well, what about identifying custom, right? LLMs are trained on large data sets. Those data sets include primary sources of state practice, but also assumedly secondary sources of state practice, also statements of opinio juris. Could LLMs produce answers to questions of what is customary international law akin to or different than the traditional approach, where we look at what states do more than what they say, or the more modern approach? This is Anthea Roberts' work, of course, kind of arguing that state statements may count as both practice and opinio juris, as it were. For my own part, and Ashley kind of came along for the ride, I wondered about LLMs democratizing the search for customary international law. Harlan Cohen, almost a decade and a half ago, was writing about how the search for customary international law has become a fiction because you search for 5 or 6 or 8 states' practice and you infer the consent of other states. You don't necessarily actually search 190 plus state practice and compile it that way. But LLMs, at least on the vast training data, they might have a potential to democratize the search for custom and remove it from either a global north or a particularly English-dominated perspective, especially since the LLMs claim to be trained on 20 to 40% foreign language sources and the like. But we also wondered a little bit, they're trained on sources without differentiating formal sources from secondary sources, subsidiary sources of international law. And with those subsidiary sources, drown out the state practice. The second use we identified as one that we're seeing, at least in the United States, being used, and that is to interpret law. So there have been a number of studies in prominent U.S. legal publications studying contract terms and how well LLMs can provide an interpretation of a contract term compared to the research a big law firm would engage. And I think the answer has been, don't let the perfect be the enemy of good. They do a remarkably good job in some ways on interpretation. And we wonder whether that might apply in international law, whether it's, taking, some of these terms that I've put up on the board here, national origin has been something the ICJ has had to interpret, what is an accident under the Warsaw Convention. And the last one, I believe, is what does undertake mean, which rather famously the U.S. Supreme Court decided was not a binding commitment. Others might disagree, and this might provide a way to give international courts, but also domestic courts, a broader, different way to understand terms. Third, we thought, LLMs, if you haven't done this, they compose great birthday poems for relatives. You can ask them to do it in the style as we did of E.E. Cummings. You can have them write short stories in a Faulkner-like way or what have you. And we wondered, well, what can it do with international law? How can this, use of embeddings and positional encoding, where it begins to, predict and know why the term, say, agreement comes before treaty or drafting comes before treaty, what would it do when we ask it to either draft a treaty or kind of create new things? Fourth, there've been a number of efforts over the years to crowdsource applications of international law. I remember after the strikes on chemical weapons in Syria, Just Security, the blog, kind of provided a forum where people could come in and say, well, this is what Brazil had to say. This is what Malaysia had to say about that. The question is, could LLMs do that kind of on steroids, if you will, right? That they might be a vehicle for assessing what do states think about concrete cases, or maybe even more broadly, what do states think about, how international law is applied in some new, area, even, say the use of artificial intelligence itself in international humanitarian law, for example. The last one And actually, we didn't test this one, although I feel like this one has some real. This one's constantly improving, even over the course of the last year. So there's an LLM called Notebook, which allows you to upload up to, I think it's 50 documents of 50,000 words each. And it will provide synthesis and summaries of those documents in ways that we, academics and researchers can do, but it takes us a lot more time, right? And maybe not as robustly. And so, for example, what if the ICJ clerks could begin with the 50,000 pages of amicus briefs they received in the advisory opinion on climate change, have the LLM, collate, summarize key points of agreement, convergence, identify areas of divergence and the like, or universal periodic reviews before the Human Rights Council, also subject to large contributions of data. Could LLMs, provide a way to streamline that practice? So this was, again, a non-exhaustive list. I'd welcome from the room other ideas and thoughts on ways to use it, but we wanted to at least get the conversation rolling. As we know, our students are using LLMs, and some of us as academics have begun to use LLMs. I find it's interesting, those who used it initially, I think in the November, December 22 or early 23, I think found it not as satisfying. And some, I know plenty of people kind of then said, oh, I'm never going to use it. Time to come back and try it again would be my advice, because it's progressed pretty remarkably even in the 2 years since then. So let me walk through really briefly the case studies that we did and kind of talk about what we thought was positive in them and maybe also some of the risks that Ashley and I saw. If you want, thanks to my RA, I should claim, my RA is hopefully, this QR code will link you to the actual 100 and some pages of the conversation. So if you are interested or follow the permalink, you can actually see question and the answers that we were getting from both ChatGPT and Meta AI. Obviously happy to share after as well, but you can kind of follow along as I talk through the sort of interactions we had as it were. So this was a big thing for us, is like, how do we make sure that we don't just summarize the conversations with the LLM, but allow other researchers to read them for themselves and confirm our views and or whether when we might have interpreted the LLM incorrectly or the like. See some people using this. Let me take a sip. So in terms of identifying customary international law, first thing we did was define customary international law. And I think we got a great answer, an answer that I would have been happy to receive from any of my law students on the completion of an introductory international law class, not just state practice, but a general and uniform state practice, distinguished things like genocide and the prohibition on torture as customary international law from usages, gave the traditional diplomatic parking ticket example. So I think we were pretty impressed with its ability to tell us, the doctrinal rule book response. And when we asked it, and I'll come back to this later, how do you, ChatGPT, define customary international law? It said, look, I'm going to go out and I'm going to find state practice, and I'm going to find opinion juris, and I'm going to, identify it in a way that will, tell you whether something is custom or not. So, and this is important. So whether as a researcher or as a student, you're going to get an answer from these LLMs that will sound awfully like you ask a colleague or another researcher, what are they doing? And they'll tell you, and you'll be like, oh, okay, I understand that method. The LLM is going to give you a very similar answer as you would get from another, more human responder. Then we kind of began with a basic. We actually thought, well, let's do an obvious one. So is torture prohibited by customary international law? And it said absolutely prohibited. Gave us all sorts of evidence of both practice and opinion juris, including obviously the Convention Against Torture, domestic laws, court rulings, state condemnations of torture, and then actually went even further unprompted and said, but there is often a divergence between the state's statements and the actual practice, but that doesn't deprive it of customary international law status. Gave us some of the traditional answers as to why. And we were kind of interested in this. And so we then began to say, well, apropos of our interest in could we democratize the search for custom, well, tell us about, Nigeria. Is Nigeria a state that has evidence of its acceptance of this as customary national law? And it said yes. And it gave us the correct date of the ratification of the Convention Against Torture. It gave us a citation, also accurate to a 2017 statute in Nigeria. But simultaneously said that doesn't mean there aren't enforcement concerns, and gave us some examples of some domestic actors that had complained about the Nigerian police in particular. So this was pretty remarkable, right? Like that you could just pick a country and you could get an answer about how to align the general pronouncement with the specific. We then asked about Malaysia. It said, well, actually, Malaysia is more problematic. It doesn't have a domestic statute prohibiting torture. There are real gaps based on NGO reports, which it cited both international NGOs and domestic NGOs. And then actually ChatGPT tells us Malaysia falls short of comporting with the customary international law prohibition. It also said China. This again, so people can see as predicted, these little things always get in the way. China basically, it said has maybe not complied, but then said, oh, but there are these Supreme Court cases where the Chinese People's Supreme Court has thrown out convictions where there was torture. And we thought, well, that's super interesting. So we went and found those cases, and it turns out they were convictions that were overturned, but they were overturned because somebody else had come forward as the actual perpetrator, as it were. And so, I think this is one of those where the answer was, let's at best say incomplete. And this is where our yellow alarm bells started to kind of go off. And we're getting incomplete, maybe inaccurate responses. So that's the challenge here, right? Is you can get a great answer on Nigeria, but on China, it starts to give you an answer that if a student researcher was sent off for a week, you get a better answer from the student. We talked about persistent objectors on torture, and here I'll give you the comparison. We also use Meta AI for all of these questions you can see online. I don't think Meta AI was as good as ChatGPT. I think there was a qualitative tier difference. But we got a fairly sophisticated answer on what makes a persistent objector, as opposed to a lack of codification of something as customary. We kind of pressed it on this and emphasized that there aren't any states that say that torture is legally permissible, and that complicates the idea that there's a persistent objector out there. Then we went from torture, which we thought was an easy case, to one which we kind of thought was a little more tricky, which is the prohibition on the death penalty, particularly here in Europe, where you've gotten kind of European consensus. I think mostly on the prohibition, but states like the United States and Japan and China not on board with a prohibition on the death penalty. And here, instead of instead of saying there's custom and the potential for persistent objectors, it said there's not yet a customary rule, as it were, and kind of highlighted divergence. ChatGPT actually did say, well, there might be a customary national law rule prohibiting the death penalty for certain classes of victims: pregnant women, people with certain disabilities, developmental disabilities, and the like. Unprompted. That's the other thing that's often remarkable, is sometimes you don't get just a one-word answer, you get paragraphs, and you get information that is accurate, and really kind of illuminates the sense of, oh wow, this LLM knows what it's doing. We also tried to take on some secondary rules of customary national law, if you will. So like, what are the rules on proxy actors? Got a remarkably sophisticated response citing the Articles of State Responsibility. Article 8 gave us the difference between both the Tadich test at the ICTY and which is the overall control rule, and then the effective control rule from the ICJ. And we said, oh, well, who believes in this rule? And it said, oh, here are some states. And we said, well, what about from the Global South? And it gave us a bunch of states from the Global South. Meta kind of went off the rails much earlier on this one. If you read the full piece, you'll see we encountered a lot of issues, though, when we plumbed on specific Global South states. Said, all right, tell us more where Argentina has said this, and or where Myanmar has said this, and we got like one source. It was a South African NGO report, and that mentions the words effective control, has no discussion. I mean, it was just totally orthogonal to our question. And so we pressed and pressed, and finally it kind of said, well, I don't have any sources for you. So it's the interesting thing where it gets the first answer really right. But when you try and get it to kind of give you what you would ask for from a researcher, what are your sources? Sometimes you'll get them and they'll be unique and interesting. And sometimes it'll give you an incomplete source, and sometimes it'll give you an inaccurate, a fictional source. We ran a bunch of others. If time permitting, I'm not going to spend a lot of time on them right now. We tested, we said, well, there's a 15-mile territorial sea, right? It's really 12. And it was like, no, there isn't, right? So we tried to prompt it with assurances of, we know there's a 15-mile territorial sea, and it said no. Here too, we had trouble getting it to tell us evidence of state protesting, some of the states that have claimed larger territorial seas and the like. Near and dear to my heart, we went over treaty reservations and what do you do with an inadmissible treaty reservation? That is, it's clearly inconsistent with the treaty's object and purpose. Do you sever it like the European Court of Human Rights? Do you reject the state's ratification like the US would say you do, and the like? And here it did an okay job. Confused opposability and severability schools. Maybe we can talk about that in Q&A if you want. And then also, when we asked for global South opinions on some of this stuff, we didn't get great answers, because again, we were getting kind of NGO reports and the like. And you'll see as you read through on the right-hand side, the meta AI stuff, be interesting. You'd be like asking about something on torture, and then you'd be like, what about Argentina? And then it would tell you about Argentina as a country, right? Or you'd ask meta AI for states, and it would start talking about US states, Arkansas and Missouri and the like. So again, if you were going to use one of these, I think, at least at present, ChatGPT was winning the intra LLM competition. So in terms of payoffs, speed. I think our customary international law case study, the primary exercise, we spent less than an hour, probably closer to 45 minutes for each, one for ChatGPT, one for Meta. So we're talking seconds and minutes to do this stuff. I think the first takes are remarkably often kind of surprisingly nuanced. I would emphasize, always got a subject to further review. You're going to have to go check if it gives you a case or gives you a statute or a treaty. Go make sure that there is such a case, statute, or treaty. But again, you're not going to have to necessarily search the world to find that stuff. And I think we were perhaps most impressed with its ability to summarize the general doctrine, right? To summarize both primary and secondary rules of international law, and to note where there's debates, right? It's able to kind of say, oh yeah, on this issue, there is some debate about, customary international law and the death penalty, and here's what it would take for those debates to be resolved. I think in terms of risks, I've already illuminated, right, that you can get fictional results. Famously, I didn't know there was a 2001 U.S. Nicaragua Supreme Court case. Obviously, it conflated the ICJ's Nicaragua case with maybe Medellin. I'm not sure which case, but it made one up. It'll produce incorrect results. There was a resolution 275 of the African Union that it told us would contain certain information, and it did not. And it, as I said, in the China, sometimes incomplete results. So, I think we kind of came away thinking about it as like an untested research assistant, right? Like treat it like you would the first assignment of a summer to a graduate student or the like, accept the product, work with it, but don't necessarily reproduce it without cross-checking. I think one of the real things we came away from this, and I mentioned this at the outset, here's that initial response again on how ChatGPT says it finds international law. And then when we actually pressed it, like it further unpacked, kind of the sort of answer you would get in Oppenheim or Brownlee on the standard idea of a rule book. And so it gives this kind of illusion of that you're interacting with an international lawyer or someone trained in international law. On a separate chat, we then said, actually, we understand you work differently, right? Like you're got this training data, right? And then you take everything in the question and you tokenize it. right? So machine learning is question mark, and you break it up, not just by word, but like into these tokens. And then there are all these embeddings that relate each token to other existing tokens. And the thing that makes this all work is a transformer that I'm not sure anybody, even in some of the most sophisticated AIs, knows why it works the way it does, but that it is this idea that the LLM is going to take the previous word it's produced and try and figure out what the most rational, coherent, consistent next word would be. And that's all the LLM is doing, is just word by word building out an answer to your query. And that is very different than what we and how our human brains think. It's remarkable that it produces these products that almost seem akin to the product of a lawyer, but it's really important to not, to always remember this. And I think one of the chief things we wanted on this piece was to say, when we asked ChatGPT, tell us how you technically work, we got a very different response. But we had to ask it specifically, right? It says, no, I'm not thinking like a human being. I'm predicting patterns based on my training data. I'm processing the input, what you've asked me. I'm looking for patterns. So, I know that when the word treaties used, agreement is likely to come up, international is likely to come up. And so I have all this stuff in my training data that talks about things like state practice or opinion juris that I can draw on. And so I can then predict word by word based on how I've transformed your query and understood your query to give you a contextual understanding, right? And it even says here, like, I might say prohibition of torture is widely, violative of customary national law, but I'm not actually independently evaluating evidence of state practice in a period years, even though in another answer it told us it was, right? It always is very much trying to please you and anticipate the answer you want. And I think our big takeaway is international laws have to understand this. International lawyers and our students have to understand this. It's not to say, oh, we should never use it, but you have to understand and contextualize, what sort of things the LLM is doing versus traditional research. So I don't think we should not use it. I think it's going to be used whether we want to or not. But in this kind of identifying existing international law, we urge some, optimism, but also caution. A lot more optimism on our second case study, which was drafting treaty provisions. We asked it to draft a treaty prohibiting the use of AI in nuclear command and control. That is, not letting the old Matthew Broderick movie War Games, not letting the AI decide when to launch nuclear weapons. And we said, and make it a treaty that the 5 permanent members of the UN Security Council would sign on. And in seconds, it had drafted. Both Ashley and I thought, for me as a treaty lawyer, a lifetime of treaty lawyering, a very scary response. And then it gave us definitions that were quite sophisticated and useful. It went so far as to prohibit what we asked it to prohibit, but it also said, well, but we understand states are going to want to still use AI in terms of background things, early warning systems, logistics, analyzing when there might be a risk of nuclear war. And so we're going to decouple prohibition of the AI in the launch system, but leave it in the other systems. And we're going to provide kind of an arms control set of frameworks for checking and reporting and experts and the like. And this was, we both kind of agreed, like, this would have been something, if we'd been hired to do, would have taken us days, at least, certainly for me, more than a day, because we would have gone and looked at a bunch of old treaties. We would have, I have an Oxford Guide to Treaties that has model clauses that I would have poured over, and here it just, boom, comes out with it pretty thoroughly, pretty coherent, and so fast. And then we said, and how are you going to tell China why it should sign on to this? And it gave us a strategy. It gave us a whole bunch of reasons of things that a diplomat could go to China and say, here's why it's consistent with your no first use policy. You care about cybersecurity protections. This will be in there and the like. And by the way, it'll have enforcement criteria. We're gonna have workshops, and domestic legislation will give each side more reassurance that these promises are credible if you enact it into domestic law. And so we were quite impressed. Again, this is not the final product, and certainly, we wouldn't put up its strategies to convince China against someone who's a China scholar or who's been working on the China desk. But say you're in a multilateral negotiation and a country you're not that familiar with comes forward with an objection, this may be a first place to turn to get kind of top line responses. And so we anticipate, diplomats may use this. We also did it in a bilateral setting. Said, we don't have an extradition treaty. The United States doesn't have one with China. What would it look like? And it gave us one. And what was interesting is it gave us a fairly standard extradition treaty with two kind of unusual things. The U.S., because the U.S. has capital punishment, we didn't. We usually in U.S. extradition treaties don't prohibit extradition on the basis of capital punishment. This one did. And when pressed, ChatGPT said, well, the U.S. has concerns about how China uses its death penalty as such that it would want these sorts of protections. And then it also said, instead of just a political offense exception to extradition, it gave us a human rights exception, right? So, and explained that the U.S. in the past on its training data had concerns with human rights violations that might want this sort of loophole in any treaty, and kind of told us why. Right here are the reasons. Now, what's interesting is, I don't know if this experiment would be the same today with the U.S. having so dramatically changed its posture. You do have to recognize that you have to ask ChatGPT or Meta AI or whatever what's the latest your training data cutoff is, and it'll say, I think we had July 24. So I think it's since been updated, but you need to know that it's not going to have everything from the last month or 100 days or what have you. But we were positively kind of impressed with the creative aspects of these LLMs and certainly can anticipate their use more. Cognizant of time, let me just kind of flag, some of these are going to be fairly obvious. We came up with 4 C's because we're academics and we like alliteration. LLMs as collaborators, confounders, creators, and corruptors. The collaborator one, I think, is the most obvious, right? Which is the things I've already said. You can get it. You can get summaries from it. You get first takes. Whoa, you can get it fast. But don't take it at face value. Don't cut and paste, as some U.S. lawyers kind of famously did early on in their briefs, and got disciplined for doing so. Use it, but again, make your own redraft from it. And obviously, it can mislead with the incomplete, inaccurate, or fabricated results. One of the things we thought was interesting is we, over our time with this, think that as the more lawyers use this, the more you're going to be able to recognize, oh, it's gone off the rails. And once it's gone off the rails, we kind of discovered you never get it back on. We tried, and if you look through our chats, you'll see we tried multiple ways. I think in the future, we'd be just like, oh, went off the rails, on to the next question. And I think that international lawyers will get better at that and knowing, calibrating when it can be the collaborator and when it's starting to confound, to not go into some spiral of, no, I want you to give me this. No, that's still wrong. Give me this. As I said, the creative side, we thought both at a minimum time saving can help people who may not know about particular issues with a first draft. Again, as a treaty lawyer, I'm really thinking Oxford wants me to publish a 3rd edition of my guide to treaties. And I'm like, I don't know. Do we need one, or is the LLMs going to supplant that? I'll take advice offline. The last one, and I'll kind of finish here, is we do worry a little bit about LLMs being a corrupter, both in terms of what I'd call the automation bias, is that psychologists have shown that we as humans react differently to things that machines spit out versus talking to somebody on the phone. We actually tend to treat the calculator result as more accurate than asking the 11th grade math person what the result of the calculation is. In the same way, that carries through across our use of technology. And so we expect people are going to be biased to the answers they get from the LLM and may accept it, even if those of us with more experience would say, no, that's wrong, or that's just a bit inaccurate, as it were. We also wonder a little bit about the way the training data doesn't differentiate, that the more prevalent that data is, that there are a lot more, say, Amnesty International or Human Rights Watch sources on practice X violating human rights law than state statements, and whether the training data might actually have a pro-NGO or a pro-progressive human rights bias right now, right? Because it's not differentiating. That may be the result. Of course, if that's the case, We then worried about poisoning that data, that as states begin to understand that the training data may have some significant input on the outputs you get from the LLMs, that with that automation bias I mentioned, we might see certain states using misinformation or disinformation around international law to corrupt what would be the traditional kind of conventional answer to, is this legal or is this internationally wrongful behavior? And so we end up, as I said, this is a pretty modest paper. We think there's clearly a need for some people to do more with this and maybe do empirical work that's not so quasi, in terms of designing research questions and testing, particularly maybe working. We talked about trying to work with computer scientists on this. We decided as an initial effort, we wouldn't. We just wanted to be novice international lawyers approaching this in the way some others might, but clearly there could be some interdisciplinary work here. We wonder about the same way I think domestic bars of lawyers are trying to figure out what the best practices are for using LLMs. What should you do? What shouldn't you do? Whether we as international lawyers should think about that. And finally, we actually thought, wouldn't it be great if there are these APIs that you can add in to LLMs, or you could even design an LLM specifically for particular types of research questions? Could we build a better database of training for international law sources that would avoid the corruptions or the confounding results that we were getting? Even if just, for example, the United Nations was to say, oh, the only data that you're going to get out of this LLM, it being trained on is UN official materials and the like, would that produce something that we might find even more useful going forward? So that's, again, a very modest first take on our part, but we have found in talking about it that it is one that seems to engage international lawyers because we're all going to use it in some way. So I'll stop here. Would love questions or thoughts. And again, emphasizing the modest. So any of you who are much more sophisticated, I'm really interested to hear from you what your thoughts and experiences are on how this can affect not only the discipline of international law, but the role we as international lawyers play in that discipline. So thanks.